But moving forward, we have a very interesting session which is happening right here. So let us all put our hands together as I invite on stage Adheesh Nargolkar, partner Khaitan and Company. Let's put our hands together as he joins us with his session on startup with IP. Of course, post his session, he'll be more than happy to take a few questions. All yours.
Thanks, Isha, and thanks, ET, for giving me the opportunity to be with all of you. The topic today is startup with IP, that is intellectual property. We have had great sessions before and had sumptuous lunch, so be ready for this presentation. Okay, to give you a snapshot on intellectual properties, these are all intellectual property that are there in India. That is trademarks, patents, copyrights, designs, geographical indications, know-how, plant varieties, and semiconductors. Now, most of these are governed under various statutes, and the respective statutes have been provided before each of those intellectual properties, except some, like know-how, which do not have any statutory protection. It is governed by contract. What is the need for intellectual property protection? The first and foremost is that once you have got protection for the said intellectual properties, you can claim for an infringement. That is a statutory right that is being given to you for stopping others who are infringing your rights. Certain IPs, that is patents and designs, need to necessarily be registered for any entity to claim infringement of the said IP. Copyrights and trademarks need not be registered. That is, they have common law rights. That is, if suppose you have not got any registration for the trademark and you are still using it, you can claim passing off. That is a common law right vis-a-vis that said trademark. Copyright subsists in every original work, and therefore registration of copyright is not mandatory. These are few concepts that I thought that I will just raise it to all of you, because many a times there are some misconceptions that startups do have. They don't file for a trademark and then they feel that since they have not filed for a trademark, they don't have any protection. Same is the case with copyrights. A copyright need not be filed or registered for claiming any right vis-a-vis that said work. Certain know-hows which cannot be protected can be still protected under trade secrets. Now, there is a classic distinction between trade secrets and patents. A trade secret needs to be necessarily be a trade secret and therefore cannot be disclosed to any third party. Whereas in patents, you are required to disclose what your invention or idea is to the patent office. So therefore, as an entrepreneur, one needs to decide as to whether you would want to disclose your said invention and claim protection under the Patents Act, or not disclose it and try to claim a protection as it being a trade secret. Why protect intellectual properties? Now, there are various transactions which are going on, like technology collaboration, trademark licensing, technology licensing, for funding. Many a times what happens is startups who want to have fundings, and as we have heard in the earlier sessions, funding is very important and necessary for startups to grow. Now, If suppose you have intellectual property in your kitty, it becomes easier for you to get the funds. It all depends on what technology you have, but it is easier if you have your intellectual property in your kitty. This session is going to be more on patents. So if you have any questions other than patents, you are free to ask me post this presentation. A quick snapshot vis-a-vis what is patent law. Patents are for both product as well as processes. Post the 2005 amendment, patents are being granted for product patents in relation to chemical and pharmaceutical substances as well. But patents are given to all inventions subject to certain exceptions which have been specifically mentioned in Section 3 of the Patents Act. Some of them being software patents, business methods, or mathematical algorithms. So all these three per se are not a subject matter of a patent. So besides the subject matter, all inventions which are to be protected under the Patents Act need to fulfill these three criteria. That is, the invention needs to be novel as on the date of the patent application. Now, many a times there are entrepreneurs who come to us stating that I have an invention, I have published it in such and such journal, and I want to have this invention protected. Now, unfortunately, the fact that he has published his said invention in any publication which is available to the public, the criteria of novelty is hit. And therefore, even if the said publication is done by him, he will not be in a position to claim a patent protection for his invention. Second is, his invention needs to be inventive, that is, not obvious to a person who is skilled in the art. Now, this criteria is subjective, but just to give you an example, if suppose on a pencil someone has a rubber and one wants to just add a sharpener to it, even if it is novel, that is, it is not there in the industry, it may be therefore industrially applicable, but it would not be obvious, or rather it would be obvious to a person who is skilled and therefore will not be a subject matter of a patent. So therefore these three criteria of patentability, that is novelty, inventiveness and industrial applicability, need to be necessarily fulfilled for any entity to get a patent grant. And all these three criteria need to be looked at from a worldwide. That is, with regard to all these three criteria need to be fulfilled not just in India, but throughout the globe. As an example, many a times people come and say that I have this idea. This idea is not there in India. It may be there in US, but it is not there in India. That does not fulfill the criteria, because the fact that it is already there in US, therefore it is hit. So these three criteria need to be fulfilled throughout the globe. Just giving a distinction that even if the criteria is worldwide, the protection that is given to you is only in India, unless you go abroad and file subsequent applications through either the Patent Cooperation Treaty or through the Paris Convention. I'm not getting into the nitty-gritties of these conventions, but the fact still lies that a patent application filed in India would give protection only to Indian territory and not globally. And there is a time limit to then file subsequent applications throughout the globe. That time limit may vary depending on which route one wants to take, whether it's a Paris Convention that gives you only 12 months, whereas if you file a PCT application, it would give you more months, say approximately 30 months from the date of priority. The patent prosecution stage, and I'm just giving you a standard process. There may be certain variations depending on what procedure you choose, but the filing date is the priority date of the patent application. And in India and now elsewhere as well, it is the first to file and not the first to invent. That is, if suppose you have an idea and you can file the patent application on the basis of the idea, someone subsequently files it, you are first in queue. That is, you get a priority date prior to the subsequent filer. Post 18 months, the said patent application gets published. There is an examination process which requires a patent applicant to file a request for examination, and post the examination, assuming that the patent can either get granted or can get rejected. If it is rejected, you have an option of filing an appeal and trying your chances. With regard to startups, first and foremost, with regard to strategy is to document what you have in your mind. Many a times it so happens that the invention still stays in the mind. So it's always better that you document the idea, you record all the experimental and research data. Because in the Patent Act, there is a specific provision which states that you need to do a complete disclosure and you need to disclose the best method that is available to you. So therefore, it's always better that a logbook is maintained and all experimental and research data are documented. The inventor details. Now, having the inventor in the patent application is one of the most important items. Many a times it so happens that the inventor is named even if he is not the inventor. Like, if suppose there is a company and you just name the managing director as, or the director as the inventor, even if he does not know anything about the technology, it becomes a problem if you are wanting to sue or wanting to take action against any other entity who is infringing upon your rights. And this has happened in one of my cases wherein at the trial of the suit, the inventor has to come into the box or basically give oath that he knows the invention and he knows whatever has been invented. And if he is not the inventor, it becomes difficult for him to then put everything on the oath. Many a times, and I will explain you later as to what are the differences between what is a provisional specification and a complete specification, but inventors may change. You have an idea today, after about a year or in the meantime, there may be 2 additional inventors. Inventors need to be named as inventors in the patent application, otherwise the said inventor can challenge the patent application only on the ground that I am not being named as an inventor and it's a wrongful obtaining. Assignment from inventors. If suppose the patent application is being filed in the name of the applicant, adequate assignments from the inventors need to be taken. Otherwise, there would be a situation that the inventors have not assigned the invention to the company and subsequently they may raise this as an issue. Because unlike the copyright law, wherein whatever work that is done by the said employee belongs to the employer under the Copyright Act, that is not the case under the Patents Act. So therefore, a specific assignment needs to be taken from the inventors. Many a times, if the inventors file the patent application, they may therefore contend that they are the inventor and the applicant, which is what had happened in the Garda case, if you are aware of, which went up till the Supreme Court. So therefore, one needs to take care of these at the initial stage itself. Many startups also have developers, that is, developers developing the idea which is created by the startup or the promoter. So confidentiality agreements need to be in place between them and the developer, wherein that whatever developer creates is assigned to the startup. Pre-filing requirements, I've already spoken about how to avoid the disclosure. Next is, one needs to also ascertain that proper novelty searches are undertaken. Many a times what happens is, inventors feel that what they have created is a brilliant idea and that this has not been done anywhere elsewhere. So before filing the patent application, one needs to also conduct what is known as a novelty search or an opinion vis-a-vis patentability to ascertain as to whether the said invention is actually patentable or not, whether it is novel or not. Otherwise, what will happen is you will spend time, effort, money in creating the said idea and filing patent applications through prosecution. And at the time of examination, you will be told that what you have done is already there in the public domain, and therefore you cannot be given a patent. Another important aspect is, irrespective of this, one needs to consider that what you are doing is not infringing upon any third party's IP. Assuming that you start your business, get funding, do whatever research, spend your time, effort, and tomorrow, once you come up with the product, you are slapped with a patent infringement notice and you are asked to stop by him taking an action against you in a court of law. So therefore, you need to also understand that whatever business you are starting, one needs to see to it that he is not infringing upon any third party intellectual property rights. May it be patents, may it be trademarks. Similarly, trademark availability searches or trademark freedom to operate searches should be conducted so that one knows that you are not using the IP of someone else. Also, one needs to understand what is the intellectual property that one wants to protect. Because there are various intellectual properties, as I have mentioned before, trademarks, patents, designs, etc. Now, there can be overlapping protection which is available to you. That is, if suppose you want to protect, say, the shape of a bottle, you can protect it under the Designs Act, you can protect it under the Trademarks Act by virtue of it being a shape. So therefore, you need to therefore decide as to which intellectual property one wants to protect. While having negotiations with your partner, you need to understand that first and foremost is an NDA that you need to enter into. While negotiating, there can be various means of commercial exploitation. It may be an assignment or it may be a licensing of your intellectual properties. Ownership is always an issue. Say for example, if suppose you are taking funds, investments into the company, eventually whether the intellectual property is going to be owned by the founder or whether the intellectual property is to be owned by the company. So obviously you need to negotiate depending on what the intellectual property is, what are the funds that are coming in, and then decide as to where exactly the intellectual property would lie. You can also decide that if suppose the funds that are coming into the company are in a staggered manner or by virtue of certain milestones to be achieved, you can then decide as to whether the intellectual property will flow to the company and the other shareholders post some X milestone. Till that time, it may be held with the promoter. So all these can be factored into when you are negotiating with other partners. Filing of the patent application can be either in a provisional form or a complete form. That is, once you have the idea in your mind, you can the next day file the patent application on the basis of what the idea is. Many a times there are misconceptions that I need to have a prototype of the said product or the process at least in place to file the patent application, which is not the case. The law provides that once you have the boundary of your invention finalized, you can file what is known as a provisional specification to at least get you into the pipeline of patents. Once you do that, you have 12 months to file the detailed specification, which is known as a complete specification, which incorporates all the nitty-gritties, nuts and bolts, for which you will obviously do the experiments, data, etc. So therefore, you need to decide as to where your invention is at that stage. There are various pros and cons to it. Although I have said that once you have an idea, you can file your provisional specification, the patent office is not going to examine your provisional specification at all. The patent office will only examine your complete specification post you have filed the request for examination. So if you are taking time from the date of filing of the provisional specification to the complete specification, you are losing on the time to get your patent grant. And unless you have a patent grant, you cannot sue any third party. So therefore, you have to decide as to where exactly do you want to get into the pipeline of patents, and whether you want to expedite the patent application. If yes, then you need to file the complete specification at the earliest. Otherwise, there can be other reasons of not filing a complete specification at the earliest, because your invention hasn't moved that much. Or you want to, many a times entrepreneurs feel that they should at least file the patent application so that they can show to the world that yes, we have filed 10 patent applications, and then decide depending on the funding as to which of those patent applications we want to proceed towards the grant. There are various non-patentable subject matter, as I was mentioning about business methods, computer software, algorithms, etc., which are not a subject matter of a patent in India. As I've said that protection will be given only in India unless you want to go abroad. So for those subject matters which are not subject matter of a patent in India, you can consider filing those patent applications elsewhere. But you need to be careful that you have not published so as to not hit the criteria of novelty. Before filing the foreign patent application, there is a statutory provision that you need to take an export filing license from the Indian Patent Office, which needs to be done. Otherwise, your patent applications are to be held invalid. So therefore, if suppose you are filing a patent application elsewhere without either filing a patent application in India or taking a foreign license, then your patent application can be held to be invalid by the patent office. With regard to funding, since startups say have a lot of intellectual properties and they want to get into funding, first and foremost is, before even approaching the investors, one needs to understand where do they lie vis-a-vis at least the intellectual property. They need to conduct what is known as a vendor diligence to ascertain what assets do they have. Because many a times startups may not, I'm saying may not approach law firms with regard to all their assets, intellectual properties, etc. But before they actually go to get the funding, they should see to it that they conduct what is known as a vendor diligence, so that whatever are the loopholes, they are at least cleared out. Ownership, post-funding, I have already spoken about it, that post-funding you can decide as to whether the ownership should lie with the promoters or the company. And if suppose the shareholding of the promoter is going down, there can be a clause in the agreement that therefore the ownership of the intellectual property can shift to the promoter. Obviously all these things need to be negotiated, so therefore it's between the promoter and the company. The founder's right to own other unrelated IPs. Many a times it so happens that when you are investing, you need not give all the rights to the company. You can still hold back on certain rights which are invented or created only by yourself. So depending on the negotiations, you can ensure that certain rights are only with you and not to the company, and there are no blanket assignments vis-a-vis all intellectual property. Yeah. Thank you. I have only about 4 minutes, so I thought that I'll end the session. If we have any questions, I'll be glad to take them. Yes. Can we have some mic for him?
First one is that I filed a patent application in 2005 in India. It got published, and after examination it's still not granted, it's not decided. The examiners, they keep changing pretty often in the patent office in Delhi. So now I find that some companies have started using a part of those patents. So can I take any actions against them?
Unfortunately, unless and until the patent is granted, you cannot legally take any action against them. You'll need to expedite your patent application process. One needs to also understand the examination report, that is the first examination report, when it was issued, you had complied with all those objections, I believe.
Yes.
So it's upon you and your attorneys to expedite the patent application so as to get a grant, so that then you are in a position to take action against the third parties. What you can do is, you can at least send a notice to this entity who is infringing, stating your rights that may be claimed later.
And another question, I got another patent application done in 2004 and it was granted in 2009. And I filed at that time under PCT and got, based on the report from European Patent Office, I got the patent in India. Now I want to file an application in US. So can I do it now? Or?
Unfortunately, patenting is all a time limit game. So if suppose you have filed a PCT application, you get only 30 months, or in certain countries 31 months, to file your national phase application post your first filing, that is the prior filing. So therefore that time limit has already lapsed long time ago. So therefore you would not be in a position to protect that patent application elsewhere.
Hello? Yeah. Currently, the trademark office takes around 2 years to give you a registration of your trademark. So till that time, till you get a registration certificate, you can operate your brand as a TM. Now, what rights do I have? So supposing today, as I speak to you, I have a TM for my brand, and registration might take around 2 years. So are all my interests protected even from the time I just get a TM and not a R?
Okay. First of all, you writing a TM has nothing to do with you filing your application, because many a times there is a misconception that only once I have filed the trademark application can I write the TM along with the trademark. That is not the case. You can write your TM on adoption of the said trademark. That is one. Second is vis-a-vis your rights. Even if you have not got a trademark registered, you can still have the rights for passing off. That is assuming that some entity is infringe or is using your said trademark or any mark which is deceptively similar to yours, you can still initiate action because you always have a common law right. But obviously you will need to prove that you have the common law right.
No, I have filed it with the Trademarks Office of India. Okay, but it takes process. It
takes some time for the registration.
It takes time of around 2 years. So I have a certificate from the Government of India says that now you can use this logo or this brand name. Okay, and what I've been advised by my lawyers is you can use that TM around your brand.
Yes.
So till the time I get a registration, so are my rights still protected as the owner of the brand?
Now when you say are your rights protected, that all boils down to whether there is no third party who has already a registered mark prior to yours.
Okay.
So therefore, assuming that there is no other third party who has any rights vis-a-vis any mark which is same stroke similar to yours prior to you, your rights are protected.
The current trademark search on the website shows that there are no similar brands registered with them. So in that, is that information sufficient enough for ownership?
Well, it is not 100% because assuming that there is an entity which has not filed a trademark application and is using say an identical mark as yours,
okay,
much prior to yours,
okay,
still they will have a better right than yours because of the adoption and the use.
okay.
Incidentally, today we got an order in the Delhi High Court vis-a-vis a similar case as yours.
Okay, but
our client had not filed an application, but when they came to know about the defendant who has filed an application, they took an action because our client was using the mark umpteen number of years prior to this entity filing a trademark application.
okay. Thanks.
Yeah. Sorry, do we have?
Say there are two companies, international. So, say one is Economic, the other is Times. Economic is an Indian company, and the trademark, the brand name Economic is owned by this company. And Times is one company, say for example in Dubai, and the trademark Times is owned by them. They want to form a joint venture in a third place, and one of them, say Economic, goes and files for that joint venture name as Economic Times in a third country. Now, this name has not been trademarked in that country before, correct? So now, if they have filed that application in their own name, Economic Times, and this trademark which originally belongs to Economic, they have filed in Times name. You understand now what I'm saying? So, can we later protect it? Can we later go ahead and have the collaboration or have any agreement which protects that Economic will still remain with me? The name Economic, even in that country, will still remain with me, even though the Times company has gone ahead and asked for the trademark.
With regard to the word or the mark Economic, now whether Economic has gained goodwill and reputation to such an extent that in that country where this entity wants to or has already filed for Times Economic or Economic Times, whether Economic has gained reputation and goodwill to such an extent that one can contend that therefore Economic was ours. So we'll need to consider those aspects as well. Unless and until, assuming that there are no transborder reputation laws in those countries, it is going to be difficult for any entity to oust or to rectify the trademark registry from rectifying that mark, that is Economic Times. Unless there is an agreement between Economic and Times to say that no entity will file a trademark application for a joint mark.
In case it has already been filed, is there any legal way to protect it later? Can they have an agreement later
Yeah,
which says that, okay,
they can
Economic
very
is
well-
still owned by Economic,
Absolutely.
but it's in Times name here?
They can very well have an agreement and have this trademark struck off, assuming that both parties agree to it. And the fact that a JV will be entered, both parties can agree to a situation like this.
Correct.
Thank you. I'm being told that this was the last question. Isha? Okay. Thank you. Thank you very much.
Adheesh, we want to make sure that we say thank you to you in the right way and truly keeping the time in mind. May I request Mr. Ali Siddiqui from ETH to please join us on stage and thank Adheesh. Why don't you come on this side? As we capture this moment. Thank you so very much, sir.